Okay. Hi, everybody, and we're really sorry for the delay in getting started with our call today and with our webinar today. We just had some technical issues which we have fixed. Thank you all for joining this very important discussion, and we're very excited to engage with you all today and on this very important discussion for RESURJ. Just in case, just for the people who are not very familiar with the RESURJ's work, we are a group of feminists. It's an alliance of feminists under the age of 40 years working for sexual and reproductive justice through national, regional, and international advocacy and movement building. We work in Africa, Asia, Latin America, Europe, and the Middle East. We also work across constituencies, identities, and generations to galvanize political will for achieving sexual and reproductive justice for all. In 2016, so this year, RESURJ wants to expand its cross-regional analysis and work. We're trying to do that by bringing together and sharing experiences around sexual and reproductive rights from the different countries. We do that, doing that not only makes for more collective and comprehensive approaches to addressing these issues, but also for an exchange of success stories and lessons learned from the different regions. For that reason, we started this dialogue around the shortcomings of penal policies in addressing sexual and reproductive justice, in addressing sexual and reproductive violations. What we found was that in many countries across the world where we work, states use penal policies as a quick fix response to sexual and reproductive rights violations. What we would like from this project and this work that started in April 2016 and is ongoing is to look into ways that we can recommend to states and ways we can advocate with states to respond to these violations by instituting more comprehensive policies and not to resort solely to the penal system. What we found through our initial meeting in April 2016 and ongoing dialogues with a lot of our allies is that addressing sexual and reproductive rights and violations needs a more comprehensive approach, one that addresses deep-rooted issues and problems and seeks to change behaviors and attitudes. The behaviors and the attitudes that led to these violations and the lack of respect for these rights can be changed through measures such as comprehensive sexuality education, access to sexual and reproductive health information, and breaking the taboos and stigma associated with these issues. Through the media, for example, working with men and boys to deconstruct masculinities, shifting norms on accepted sexual behavior, and so on. So this is just a very brief introduction about what we'd like to discuss today through this webinar. We have 4 outstanding speakers that will be joining us today. We have Maliha, who is the team lead capacity building from the Legal Aid Society in Pakistan. Dalia Abdel-Hameed, the Gender and Women's Rights Officer from the Egyptian Initiative for Personal Rights. Jaime, Todd-Gher, who is the legal advisor in the Law and Policy Program at Amnesty International. And Sinara Gumieri, researcher and legal advisor at ANIS, the Institute of Bioethics, Human Rights, and Gender. She is also a member of RESURJ. The way we would like to structure this webinar today is I will start by asking the speakers some questions and ask them to answer the questions, and then ask them to answer the questions. We'd like each one of you to we'd like each one of you, if you have comments or questions, to just write them as comments below the video, in the YouTube channel, just below the video. And we will, once the speakers are done speaking, we'll share the questions and comments with them and ask them to react. Thank you once again, and I will go ahead and start with our first speaker, Jaime. I'd like to ask you to speak a little bit about what we've learned from our work on sexual and reproductive rights violation at the international level in terms of criminalization and penal policies.
Hi, thanks, Soha. Hi, everyone. I'm really excited to present on this webinar, and I thought it might be useful just to talk about some work we've been doing at Amnesty International. I lead a project that focuses on the human rights impact of Criminalizing Sexuality and Reproduction. And under that project, we focus on issues such as abortion, same-sex sexuality, adolescent sexuality, sex work, HIV exposure and transmission, sex outside of marriage, basically all of the issues that we found that governments around the world criminalize. And the overarching aim of our project has been twofold. First, we've just been trying to build Amnesty International's own capacity and understanding around these issues and to motivate our own movement to take them up. And second, we've been aiming to foster cross-sectoral intersectional analysis about these issues. So we've been working on the project for about 5 years now, and I thought it might be useful just to share a couple insights that we've gained over the years. The first thing I wanted to talk about was being mindful of the history and context behind our work. As most of you know, women's human rights weren't even considered human rights at the inception of the human rights movement. And it really wasn't until that the global feminist movement demanded access. And the issue that we were able to accomplish this by was primarily focusing on violence against women and sexual violence. Over the years, we have obtained recognition of women's human rights, and some of the most advanced normative standards have been around violence, and in particular states' due diligence obligations. But I think that because of this history and context, women's rights advocates, feminist movements have really become accustomed to looking to the state to remedy violations and to provide protection. So with that first insight in mind, the second key point I wanted to make was that we as an advocacy community need to start to release our grip on seeking criminal justice remedies for human rights and sexual and reproductive rights violations in particular. And we really need to look to donors, states, law and policymakers, and allies to do the same. This is a really big ask, and it's quite difficult because there's a lot of political capital calling for criminalizing things. It's, as Soha mentioned, a quick fix to some issues, or perceived to be at least. But I think that we've come far enough in our human rights advocacy around sexual and reproductive rights, and now that we can say that sexual and reproductive rights fall squarely within the international legal framework, that we have the space and capacity to think about more transformative advocacy calls and remedies. In particular, we need to start thinking about, remedies that advocate for real structural change, that tackle gender stereotypes, and achieve accountability in ways that are not just through penal systems. I think this is a critical point, just because I think we're now more aware of the harm that criminalization causes, and that it not, calling for states to punish something isn't only a matter of trying to protect someone, but that actual punishment can lead to other harm. And this is really important for those of us who inhabit multiple marginalized identities. And so some of my colleagues on the calls will talk about the practical realities of what it's like to live under a criminalized regime, but I just wanted to flag that here. A third critical insight that we've gained in our work is that as an advocacy community, we need to start doing a better job of collaborating and working together, and to avoid having our advocacy being disjointed and duplicative. I think really the criminalization frame is key to that. It provides a strong analytical starting point where we can find the commonalities between our groups and our constituencies. And it's a way to demonstrate that states' criminal justice approaches impact us in similar ways, and that together we're stronger. And as an add-on to that, I think that we also need to release sort of a notion of looking for the perfect victim. When you start doing criminalization advocacy, you have to be able to embrace people who transgress social norms, people who are criminalized, people who are accused of grave crimes. We have to be able to really come to terms with advocating for people who aren't palatable to all. And a final insight I'd like to share about our work is that the international legal framework does have a lot to offer advocacy, but also we have to acknowledge that international legal standards around criminalization issues are incomplete. And this isn't necessarily a reality that we're not accustomed to as sexual and reproductive rights advocates. We've been engaging in advocacy with incomplete legal frameworks for decades, but it's something that we should be cognizant of. And I'll get into this a little bit more later in the webinar, but these are just some key insights that we've learned that hopefully can be helpful in your own advocacy. Thank you.
Thank you, Jaime, very much for that. Our next question, Sinara, would you please tell us what are some of the most common problems associated with the criminal justice system?
Sure. Sure. So I'd like to reflect on, for example, coming from the reality in Brazil, when we talk about the fact that we have a specific criminal law, for example, for domestic violence for 10 years now, and it is usually addressed as a big winning for feminist movements and women's movements in the country. And it is in some aspects because it brought us, for example, the possibility of talking about gender in our policy here. It was the first legal piece that we had that talked about gender. But then it also got us thinking about the downsides or the limitations of this approach to domestic violence, which is a huge issue here. So I guess one of the first things that I wanted to point out is that we sometimes fit into the discourse that having punitive laws in place or having more strategies for punishing people is going to change their behavior, and that's not true. So addressing criminal law as a tool for prevention, for example, for whatever we want to prevent, is not working. We have no evidence that that's a good or necessary approach to change the way people act. So that is one of the things that we need to understand, because we keep on sometimes repeating that idea that we need criminal law to change behavior, to make sure people know that they're going to be punished and therefore they're not going to do this or that. But it doesn't really work like that. Our behaviors there are many factors that go into them and into violent behaviors. So it's not the idea of being punished that it's going to change it necessarily or automatically. So that is one thing that I'd like to address. There's something else that has to do with, in many of our issues, which are complex issues, for example, domestic violence or violence against women, it has to do with our cultural norms. It has to do with women's health. It has to do with women's access to the workplace, women's ability to be economically empowered. So it is a very complex issue. But then when addressing it solely through criminalization, we kind of lose sight of those other aspects of it, and that can be that doesn't help. In fact, it can, if we only talk about it through the perspective of criminalization, we have a hard time addressing the other factors, the other issues around the problem that we're trying to face. And when that intersects, for example, with sexual violence or with issues of health in a more direct way, it can even be harder to address health consequences, because the space in which we talk about criminalization or in which we enforce it, for example, the police stations or the criminal justice system, is not welcoming usually for minorities, for women. And it creates a sphere of fear, of stigma, which may make issues even more difficult to talk about, to discuss. And so, for example, I wanted to, and also because the criminalization approach is an individualizing one, it cannot do much on its own to challenge the norms that allow these practices or these violences that we want to challenge. So, for example, in Brazil, as I was saying, we have this criminal law against domestic violence since 2006, and it was the first time that we started discussing gender in our policies here, and that was a big important point. And this piece of legislation was interesting because it wasn't just criminal, it was also, it had civil aspects to it. So it was trying to address some of the other, of the many aspects of domestic violence, which was great, but that did not cut on. So what we keep doing in Brazil is that we're trying to implement the criminal aspects of this legislation, but not really the other aspects of it, because criminalization is sometimes a colonizing approach to the issues. It is as if it's easier to say we're going to punish people, we're going to maybe put people in jail, but we're not going to be able to do anything else because that takes up a lot of our resources, a lot of our time, a lot of our, whatever we can do. So that has been happening here with the Maria da Penha law, which is our domestic violence piece of legislation. We have been enforcing this idea that perpetrators are going to be punished, but we have a hard time applying, for example, the urgent measures that we need to have in place in order to protect women, to make sure that women who are coming forward with their stories of violence have an alternative, for example, of somewhere to go, of a shelter, of ways to make sure that themselves and their families have ways to support themselves when they decide to try to get out of a violent relationship. So this colonizing aspect of thinking that punishing or that response should be the primary one can have problematic effects. And just to finalize on that, what we have been seeing in Brazil is that despite the fact that we have criminal legislation that talks about gender, for example, as a power structure that we need to understand and to address in order to protect people, we have been seeing on the other side this political and religious fundamentalism based movement to sort of abolish the talk on gender, for example, in schools. So our main tool for prevention, for changing social norms, in fact, which is education and addressing gender and comprehensive sexuality education in schools, for example, is being targeted as something that we don't want to talk about, as something that we're not going to discuss, is being even prohibited by legislation, by bills here. So we need to understand this paradox. How can we have these criminal policies in place, which are supposed to be talking about the social norms, but at the same time, we can't really address them in transformative environments such as education. And that has to do with how states seem to be much more willing to go forward with criminal measures, but not necessarily with transformative ones in terms of social policies, of social protection, of education, of educating people to be able, teachers and professors to be able to be discussing these issues with kids and adolescents. So I guess understanding in different contexts how these contradictions play can be a way to understanding how we feel that criminalization is not necessarily, has not been the greatest approach to the issues that we want to discuss and question.
Thank you, Sinara, very much for that. Moving on to our next question, Dalia, could you please share with us issues that we have encountered through our work at the national level?
Thank you, Soha. I think our main challenge actually at the moment is related to how we arrive to the law. It's not that the law is, how the law is important, how it's not important, but it's whether the law is really implemented or not. And it's the process of how we are actually arriving to the law. I will talk about two examples from Egypt of legal changes. One of them is extremely effective and the other one is a total failure. And I think I want to engage here with actually the approach that we are as feminists are actually adopting in changing laws and policies regarding sexual and reproductive health and rights. Namely the bottom-up approach and the top-down approach. The first example is regarding the law against sexual harassment in Egypt. By the wake of the millennium, we had an epidemic sexual violence against women in the public space in Egypt. where women are being mass assaulted in any given gathering, like Eid festivities or protests or concerts or matches. That problem was faced by complete denial from the state and from the society, where a prevailing blaming the victim culture was actually facing the survivors of these attacks. And also a long list of justifications are being provided to the perpetrators of these sexual violence attack. What helped us in resisting this is the grassroots organizations that the anti-sexual violence groups did during the revolutionary years. The sexual violence attacks took a very violent turn with the revolutionary years in Egypt from 2011 to 2013. And as a response for this very violent turn, hundreds of young women and men organized themselves to resist actually these kind of attacks taking place in Tahrir Square and elsewhere in Cairo and other places in Egypt. And that form of organization against sexual violence against women in the public space allowed us as feminists to have our voice heard. And we managed actually to end the long-lasting denial from the state, and we managed actually to end partially the stigma and the shame associated with sexual violence. And the law this all effort actually culminated in changing the law only in 2014 after years and years of grassroots mobilization. And for the first time in 2014, we had the word sexual harassment in the law in a state of indecent exposure. And the result is actually a very successful and widely implemented law. And instead of having only one court case in 2008, now we have hundreds and hundreds of sexual harassment cases in the courts where women feel more empowered to take their harassers to the courts, and they feel less ashamed of talking about being subjected to sexual violence. At the other end of the spectrum, actually, there is the state approach for change, for actually addressing sexual and reproductive health and rights violations. What the state did with the problem of female circumcision in Egypt is actually a case in point in how laws could actually be a complete failure if they are being imposed in the society without actually working on changing people's perceptions and people's convictions towards any given practice. The Egyptian government actually criminalized female circumcision in 2008, while totally ignoring that the vast majority of population are still convinced that female circumcision is necessary to protect women's piety and morality. And also, people think that female circumcision enhances the marriage prospects of their girls. Criminalization in this case was extremely futile. Now, after 8 years of criminalization, we had only 3 cases of female circumcision that reached the courts, while actually the prevalence of female circumcision in Egypt is more than 90%. And the only cases actually that reached the courts are the cases when the girl actually unfortunately died while being circumcised. This year, and after the death of yet a new girl while being circumcised, the government decided to amend the law. And instead of looking why the law actually failed from the first place, the government decided just to increase the penalties. And this is something we need to discuss, actually, harshing and increasing penalties as a way to confront violations of sexual and reproductive health and rights. Now, with increased penalties, nobody even would report any kind of circumcision. And now, because also parents and doctors who are doing female circumcision are are facing harsher prison sentence, they would actually tend to cooperate with each other to cover up for their crime. The problem is now we are not in 2011 anymore. So actually we don't have any space for organization on grassroots level. So this is another actually challenge we are facing. What we do if we have to mobilize people only around the law. The law has to be our point of departure, but also we need to think of innovative ways to engage people in these kind of issues, like how to remind people that the fact that millions and millions of girls in Egypt are being subjected to female circumcision each year is a state failure. And it's not only actually the doctors and the parents that should be blamed, but actually the state itself should be blamed. How we actually remove the stigma from female circumcision to allow women to talk about their experience with circumcision in an empowered and not victimized way. How can we push them to ask the state for legal remedies and for compensation for being subjected to this kind of violation when they were young? These are just some of the challenges and the questions that we are actually now in Egypt, we are thinking about of how we can engage around the law, how we can work against the state, but still at the same time through the state. everyone. It seems like Soha can't unmute herself, so I'm addressing the question instead of her to Maliha. Maliha, would you please tell us what are the kind of actions and solutions that need to be explored to resolve this issue?
Thanks, Dalia. I think that one of the things that we have been looking at in recent years, particularly, keeping everything in mind, where we're not, the current criminal justice system is not particularly victim-centric, is that we cannot look at it just in the sense of the aftermath of a form of violence. We actually need to start looking at the criminal justice system as a whole, from the perspective of prevention to the entire criminal process itself. So we need to revise the whole thing as opposed to just looking at what should the end result be, because that is very common and easy to manage, and which again, as we've seen, has not had results. So I mean, you can talk about education of children, but what we need to start talking about is the kind of curriculum that the state institutions study. What are the judges looking at? What are the police looking at? And more so, what are they being judged on? So while our state has not done so in Pakistan at this point, very recently some international corporations have started putting in gender assessment tools for purposes of employment, on the basis of which if they don't pass those assessment tools, they do not get the job. And any promotion, any even confirmation is based on this. So that is something we've also been talking to our state about in Pakistan, is that for any state government, because one of the issues that we've also had mentioned particularly is that while we may have the law, its interpretation and implementation is always a problem. So we need to make sure that the state actors who are involved have a predisposition to be more aware and sensitive to the issues at hand. So in order to do that, we need to make sure that the people who are employed have a certain training or understanding of gender, of violence, of sexual violence. And in order to do that, we need to make sure that we have the clarity of where their stance is at the beginning. And that stance must be measured at every level of their employment. So that is one thing in Pakistan that we are at least exploring with the state, that from the very first day that they get measured on this. The other thing that we have also been talking about, and I do believe the UN has touched upon this briefly, UN, ODC, and a few others, is to start looking at pre-trial measures. Whether it is a question of allowing some of the cases to be heard out of court. One of the things that they have started in Pakistan is in small claims, there is mediation, where they have appointed committee members who are allowed to mediate and look at, take some of the testimonies and examine some of the witnesses out of court, so that the stigma of court and the fear and the double discrimination and torture that they face and the re-victimization is taken away from the courtroom. But having said that, at the same time, it is also necessary that any of these committee members must also go through some kind of gender training and must be measured and make sure that they uphold standards of sensitization and are not behaving in a manner that is not appropriate for such cases. So these are some of the examples that we're looking at, but I do feel that something that we've talked about here regionally and internationally as well is that we absolutely cannot look at it in an isolated thing. We cannot look at it as an after the violence happens, what should we do? We have to start looking at it, the entire system altogether. And even after that, there are other methodologies of trying to make sure that these people are taught not to violate women. I mean, whether it is detention, whether it is house arrest, or whether it is forcing them to go through certain courses. I mean, of course, depending on the level of violence that they have committed. But there are several options as opposed to just imprisonment that we must look at. And another thing that in the Pakistan domestic violence bill, which unfortunately has not been successful to date, but one of the things that we have looked at is taking damages as opposed to just criminal penalties, which courts are a little bit more welcoming towards as well. But we do look at, for example, penalizing them, not just in terms of a token amount, but holding on to some of the property, for example. So, I mean, there are many alternatives that we can look at. Everything has to be catered to each country and each situation. But again, I would like to reiterate that we have to look at the whole system as opposed to just one particular circumstance. Dalia, I'll hand it back to you now.
Okay, I'm gonna use Dalia's his phone, who's sitting right next to me because we're both from Egypt. Because I for some reason I can't seem to fix my mic thing, even though it seems to be working on other venues. And anyway, Maliha will want to stick with you and ask you a follow-up question. Are there any relevant or current or ongoing initiatives towards the same?
I think largely at this point, so a lot of it is still in discussion. Um, what I have seen at this point, especially in the South Asia region, there's still a lot of discussion going on against. Of course, as we all know, that there still has always been a push for criminalization. So to change the mindset and try to look towards other options, it's still not in a practical level at this point of view. So we're exploring options and we're talking to different people and trying to come up with practical, realistic solutions, especially when we're talking about in South Asia, where not a lot of money is spent and not a lot of budget is appropriated for these kind of causes. So we're also trying to see something which is cost effective and manageable. So at this point, unfortunately, I apart from maybe the small claims mediations in some of the Pakistani courts, I can't really say that I have seen anything successfully work at this point, purely because that it hasn't been fully implemented.
Thank you, Maliha, for that. Moving on to the next question. Jaime, back to you. What do you think? What kind of contributions can the global landscape and international human rights framework play in addressing this problem?
Thanks, Soha. I think that actually the international legal framework has a lot to offer. We have to recognize that, a key issue at the beginning, though, is that the international legal framework is mixed in that it does actually call on states to criminalize things. So we have, to one extent, states are obligated to take punitive measures to comply with the international legal obligations, but then we also have these other international legal standards that we can look to challenge states' punitive approaches. So to some extent, the international legal framework is a mixed bag, but I do think that there is quite a lot for us to frame our advocacy. Just to go through quickly a few key points that we can look to when we're trying to develop advocacy framing and messaging, is that there's very key long-standing human rights principles that limit the extent to which states can criminalize things. And this is framed in the way of states cannot pass laws and policies that infringe on our human rights without meeting certain requirements. One of the long-standing requirements is the principle of legality, and this is a really foundational principle that it requires that any crimes that states legislate must be defined in law in a manner that's accessible to our population and clearly outlines what's criminalized. And this principle is violated all the time by states' criminal laws. I mean, we often see very broad laws that aim to prevent very intangible social harms and generic public morality laws, and they're often used to criminalize a wide range of behavior. And this is the type of the law that would clearly violate a principle of legality. Another key human rights principle that we can look to is that states' criminal laws have to have a legitimate purpose. And so to actually justify infringing on our human rights, they have to have a legitimate aim. Under international law, there's a few purposes that have been claimed or have been identified as legitimate, issues such as public security, public health, protection of the rights and freedoms of and others. And there's also, unfortunately, morality. But I think evolution of international standards has debunked the fact that simply legislating because society doesn't like particular conduct, particularly in the realm of sexuality, is not enough to satisfy this element of a legitimate purpose. So this is another way that we can attack and critique a state criminal justice endeavor. Another key human rights principle that I think we need to think about is the principle of necessity. In general, it's accepted that using criminal law should really be the last resort by states, and that if there's another way that we can achieve the aim of changing behavior, preventing harm, we should be using that approach first. And I think that this is where a lot of our advocacy should focus in terms of producing research and examples of taking alternative approaches to achieving the state aim. Alternative dispute resolution, investing in poverty reduction, public education, sensitization of the community and law enforcement officials. I mean, these are all measures that we can demonstrate have a tangible effect beyond simply criminalizing and punishing something. So if we can produce as advocates evidence and research to demonstrate that, we can show that it's not necessary for a state to criminalize something, and that actually it would be more effective to take an alternative approach. Another key human rights principle is the principle of proportionality, and this is an issue that I think many criminal laws, specifically punishing sexual and reproductive conduct, can be challenged on. Many laws produce, really harsh criminal punishments for conduct that it's questionable at all whether it's even harmful, and simply because, it's conduct that maybe some members of the community don't like, we can challenge even whether that is a harm that justifies criminal punishment. And finally, just the long-standing international human rights principle of equality and non-discrimination. I mean, almost every criminal law that focuses on punishing sexual and reproductive conduct can be demonstrated to have a disproportionate impact on marginalized communities. And so that in and of itself violates the principle of equal protection. So this is often, one of the key points, the entry points that advocates take in terms of challenging criminalization of sexuality and reproduction. So the international legal framework is a mixed bag. It does explicitly call on states to criminalize things to some extent, but we do have some strong international human rights principles that we can rely on for. The international legal framework is a mixed bag. It does explicitly. I think I'll just end my comment to our response to Soha's question by saying that, I think actually our most challenging work will be convincing law and policymakers and the wider community that taking criminal justice approaches to complex social issues is problematic, and we need to really think about, in terms of our advocacy, is how do we sort of shift the mindsets that criminalization is effective, that it reduces harm, and that it protects the community. Because until we, work towards some of that sort of wider mindset change, I think our international legal advocacy and our international human rights advocacy may be limited. So I think that's something that, as a global advocacy community, we need to think about more specifically. Okay.
Sorry, Soha, can I just add in a little bit here as well? Just to follow up on it, I think the other issue that we are facing, particularly in Pakistan and perhaps in India as well, is that apart from the ineffectiveness of criminalization, the other issue is that the negative effects of overcriminalization. For example, where we have had higher punishments for gang rape has resulted in a reduced successful prosecution for gang rape. We've had recent amendments in the rape law in Pakistan where the penalties are death penalty and life imprisonment. And I am very nervous about that because I feel that judges and police officers who are already sympathetic to the cause or to the perpetrator are going to be even more wary about actually punishing perpetrators for sexual violence. And in addition to that, the investigation will also be flawed as a result. And I feel that apart from just the community and the wider mindset, we also need to figure out how to advocate within women's groups as well, because they need to understand the legal implications of all of these things. And I agree with Jaime is that a lot of the data collection and actual witnesses and evidences of these situations will help in trying to create a mindset change.
Thank you, Jaime and Maliha. I think Dalia's also next intervention is will follow up from Maliha's point about how much do we want the state to sort of how do we balance between the state role and state obligations, but also how to manage the state role in our community awareness efforts.
Thank you, Soha. I think it's always tricky to know when we invite the state to intervene and when we invite the state to retreat.
The state role
to know. So in Egypt, for example, we are currently actually facing a very systematic crackdown on gay men and trans women, where the morality police actually heavily monitoring the gay and trans dating websites and applications. And they use a technique of entrapment where the police officer would, or the police informant would create a fake account to chat with gay and trans people and fix appointments with them and then arrest them. The law used to justify these arrests is a medieval article called, in the penal code called the habitual debauchery law, which is a pretext for criminalizing homosexuality in Egypt. In our defense and in our demands for the state to refrain from these kind of arrests, to stop actually monitoring and cracking down on gay men and trans women in Egypt, we ask the state to respect the right to privacy of the people and not to intervene in people's personal sexual conduct, and not to follow people in their bedrooms and not to decide to them their sexual behaviors. But at the same time, as important the right to privacy is, I always feel very afraid of overemphasizing the right to privacy because that might actually refine the wall between the public and the private sphere. So the question here is, do we really want the state not to intervene at all in whatever happening in the private sphere? The problem is, yeah, people personal sexual behavior taking place in private sphere, but at the same time, domestic violence against women also takes place in private sphere. Female circumcision takes place in private sphere. Incest and sexual abuse of the children takes place in private sphere. And we and our feminist ancestors have fought for many years and years actually to politicize what is going on in homes under the motto of the personal is political. So I think the question here is, yes, we have to ask sometimes the state to respect people's privacy, but not only talking on privacy, because also far-right groups in Egypt, like Salafis and extreme right groups, use privacy to justify the right of the man to beat his wife. So I would say that we should employ right to privacy in our work. We should ask for less state intervention, specifically when it comes to LGBT. But at the same time, I think we should also engage more and more with the concept of consent. And I think this is something that we haven't done our homework in it yet. Because, for example, in Egypt, consensual sexual encounters between adults are not criminalized. So how we can actually push for this legal protection to to include all the type of sexual conduct and encounters, not only the heteronormative ones. Another important and decisive factor is related to age. What the state should do to minors, and because also some of the state officials would use actually freedom of choice, for example, to say that some to justify that girls in primary and preparatory schools in Egypt are being obligated to put on veils. So this is very problematic. I think the issue of age and the issue of consent need from us more attention. But on the other hand, as many of the speakers actually today said, it's not only about laws, and we have always to remind ourselves that state obligations to human rights is threefold. It's not only to protect. I think we always, our mind functions only in the protective aspect, but we forget that that actually women, that the state has to respect and also to fulfill human rights. And many of you actually talked about comprehensive sexuality education, and we find the lack of comprehensive sexuality education is a great missed opportunity in Egypt. The state invests billions and billions in changing laws, in working on campaigns like vertical funding against sexual harassment, another vertical funding against female circumcision, and many other issues, another vertical funding for family planning and population policy, while actually totally ignoring the state's obligation to provide young people and adolescents with comprehensive sexuality education, to inform them about gender equality and about gender-based violence, to make them more able to take decisions regarding their body, to inform them about STIs and about female circumcision and about family planning and many other issues actually facing Egypt. Also, the comprehensive actually or the universal access to sexual and reproductive health services also is severely lacking in Egypt, with huge stigma attached to young people and unmarried people who are trying to get these kind of services or these kind of medical checkups. The state has a lot to do when it comes to availing these kind of services, to make them free from judgment, to guarantee people's confidentiality and privacy while actually they are seeking medical services. All these other obligations on the state, in fact, are the ones that proven the lack of these kind of services and the lack of these kind of education and health services is the real proof that actually the state lacks political will to address issues of sexual and reproductive health and rights, because it's so easy to put a beautiful law and not implement it and then go in the international fora, in the UN and elsewhere saying we changed that law, we put that policy, but we didn't do our homework or we didn't do whatever is necessary to make that or this policy effective.
Thank you, Dalia, very much for that. Jaime, you also wanted to add something?
Yeah, I just wanted to say that I completely agree with Dalia in terms of being mindful of confining our advocacy framing to privacy. And we don't want to sort of create the situation where our sexual and reproductive autonomy is limited to the private sphere. And I totally agree that we need to think about sexual consent, and think about what constitutes harm, because these are two key issues that can be potentially used for the beginning of an analytical framework of what constitutes legitimate versus illegitimate criminalization. And by focusing on sexual consent, we can remove some of the analysis out of the private sphere and focus it more on the individual. This becomes a little bit more complex when you're engaging with, sexual relations between people, but it's not something that we cannot overcome. But it is a way to think about the issue beyond privacy. And I also think that sort of as an advocacy community, we need to come to terms with what Dalia mentioned, that decades of advocacy and activism has focused on reducing and eradicating violence in private spheres. And a lot of advancements have been made. And how do we now sort of call for decriminalization or engage in decriminalization advocacy that's mindful of that doesn't necessarily detract from that? And I think, there are some amazing normative developments that are happening right now in terms of, trying to figure out what is the dividing line between legitimate and illegitimate use of state criminal laws and policies. But I think for us to move forward as a movement around these issues, we need to come together and decide on our own platform, and bringing together constituencies from all across the various different issues, and what do we think is the dividing line? What do we think is a legitimate base for state to use its policing power? Because until we do so, we're going to continue to have sort of these sort of disjunctive, fractured advocacy that where some feminists completely disregard with some women's rights groups and LGBT rights groups, and until we take the sort of movement time to come together on a shared platform, I think that it's going to be harder to move forward. And just sort of contributing to the normative developments that are happening at the international level, it won't be as transformative as if we as a movement decide on a shared platform. So I just wanted to put that out there for the group to think about. Thanks.
Thank you, Jaime. Just to move to our last question, and then we'll to our speakers, and then we'll take questions we'll take all the questions that you guys have listed, and we'll share them with the speakers as well, and ask them to respond. Sinara, can we conclude with you? And can you please share with us some thoughts on how we can advocate for a more comprehensive approach that ensures justice is upheld, and what should be our main messages?
Yeah, thank you, Soha. I just wanted to, I guess we kind of addressed that in the previous questions, and I was listening to Jaime and Maliha and Dalia, because I guess one thing that we need to work on when changing our advocacy messages is to actually be able to talk about this issue, because sometimes it feels like, criminalization is a necessary step. When we talk about not doing it, it sounds like we're taking a resort out of the question. So I know, for example, that in Brazil, for the LGBTQ community, criminalization of homophobia is an issue, and it is hard to sort of question if that's the way to go, because it feels like we're taking the last resort. So I guess I don't have of course the answer, but I guess some of the things that we should be trying to address as a movement when coming together with movements to discuss why criminalization may not be the best approach. One thing is that sometimes rely on this idea that of the symbolic value of criminalization of the criminal laws starting a conversation that is really important. But maybe we need to remember that it's not just the passing of the law that creates a debate. There's a lot of people trying to move the conversation, to create language for it, to mobilize, to having campaigns. So maybe just remembering how all of the strategies that we put in place when we're trying to discuss new legislation, it's important to remember that there's a lot of value, of symbolic value, of movement that comes from there, and not necessarily simply from the idea of passing a law. So I guess that's one thing to address, this fear of, if we can't talk about criminalization, then we're treating this group of people or this issue as less important than other issues, which I understand is a legitimate sentiment. But also, I guess we need to be developing our language when it comes to data, to showing how criminalization can be very harmful, how it feeds into the system, into the criminal justice system, which as we know, reproduces patriarchal and racist structures that we feed into. So, but we need data to show that. We need to strengthen our arguments with data showing that the results is not as we expect, because that also has to do with this general idea that we need to punish in order to change the way that we act, the way that we live together, the way that we build our communities. So I guess I cannot but agree with other people have said about, we need to first come together as a movement to develop the language in questioning these things. But then when designing our advocacy messages, we should be able to talk about the fact that when we just address criminal policies, when we just go for criminalization, we sometimes give states sort of a permission to forget about social policies. So we even sort of sometimes talk about it as an alibi legislation. Like, if you criminalize it, and because it is seen as a very harsh measure, as the last resort, as it should be, it kind of as if you've already done everything else, and you usually haven't. You haven't discussed education, you haven't discussed health, you haven't discussed campaigns in order to make an issue public and with an accessible language for people to be able to talk about it. So I guess two things that I'd like to highlight in trying to address this is that, first, we need to come together as movements in order to develop our common and intersectional arguments to this, because we don't want to get people and movements feeling like they are being left out of the conversation somehow, because criminalization can be seen as the only resource available for some groups. But we also need to remember, what else were we asking for when we say that criminalization is not enough? So how do we talk about social policies? How do we talk about the fact that if we can't talk about gender and race and sexuality in criminal policies, how come we can't talk about them in schools? How come we can't talk about them in the way that teachers are being prepared to discuss and to educate children and adolescents? So I guess not forgetting that never talking about criminalization as an isolated issue, as other people have pointed out, is the starting point. It's not the answer, but it is, I guess, something that we need to work on together in order to develop this language in sort of a safe space, so that people don't feel like we're taking away the only resort that they have to address their issue, to address a human rights violation, which would be criminalization, if that makes sense.
Thank you, Sinara, and thank you for all the speakers for their very interesting presentations and thoughts. We'll start with some of the questions that were coming throughout. Our first comment and question was from Susanna Fried. She said, with our project on criminalization with the OHCHR, we are trying to grapple with the following question. If criminal law is supposed to express social disapproval of certain kinds of actions? And then as a follow-up to that, is there a danger that decriminalization will be seen as approval of these same actions? For instance, gender-based violence. Sinara, do you want to start us off with an answer or comment on this?
Yeah, I guess it has to do with what I was trying to say earlier, because I understand, because we got so caught up in the idea that what we can do to say that something is socially disapproved is to criminalize, that it's hard to challenge that. And I understand that we always face a lot of rejection to the idea of decriminalization. But then again, we need to address what other things we're not doing. It is a contradiction that we have, at least in Brazil. I'm thinking about, for example, the way that we discuss gender-based violence here, or violence against women, or feminicide. We have these laws in place to say that it's not acceptable to violence against women is not acceptable. Killing women for being women is not acceptable. We're saying that we have that idea because of our criminal laws. But at the same time, we are accepting this discourse that says that we shouldn't be talking about gender in schools. We should have neutral schools. We shouldn't have these critical spaces for discussing oppression. And because we don't want kids and adolescents to be brainwashed or some idea. And these ideas are very popular here right now. So we need to address this contradiction that when we talk about social disapproval, we need to talk about that sometimes in some issues with criminal laws. But what else? Should we make sure that we have health systems in place to receive women who have been victims of violence, receive LGBT people, so that they are actually able to talk about what they've suffered or what they go through on a daily basis with health professionals? Should we have public campaigns in place to visibilize the issues, to make them heard? Should we have discussions on, is it not necessary, or is it not important for our ideas of social approval or disapproval of conduct to say that violence against women is such an important issue that we need to discuss it in school? That we need to be able to develop language to talk about that with adolescents, with kids, in a manner that is appropriate to their age, but we need to be able to discuss this early on in our schools. So it's not easy. I know that the general idea that the way to address something as socially disapproved is criminalization is very hard to challenge. But we need to remember the contradictions that we're buying into when we only talk about criminalization as the way to make something socially unacceptable. Because we are sometimes feeding into this rhetoric of, if we criminalized it, if the state has passed a criminal law, then it's done everything it can. And it usually hasn't even started doing anything. And in terms of protecting people, of prevention, of reparation. So it's not a direct answer, at least I don't know of any, but I guess broadening the conversation around the way we want to address these issues and starting with our own movements, within our own movements, is a first step, maybe.
Hi, this is Jaime. I just wanted to follow up and respond to Susanna Freed's question. I think this is a fantastic question, and that it is the expressive function of criminal law that makes it so difficult to convince people to release their grip on looking towards criminal justice responses to things. People really do believe that when you criminalize something, that you're expressing social disapproval, and you're reducing that stigmatized or conduct, that it actually works. And so we really do need to answer this question. How do we deal with communities that want to have the expressive function of criminal law, who want to communicate as a society that some things are not okay, some things are disapproved by the community? First, we have to think about what is a potential alternative. What is another outlet for this type of expressive function? And I don't know if that's focusing on greater forums, for freedom of expression, for community discussions about how they feel about things. I don't know. I think we as an advocacy community need to think about this. But I also think that we could probably use some of our efforts to use and develop evidence that actually the criminal law's expressive function isn't working. So if criminal law isn't actually preventing conduct, to some extent, the expressive function is not functioning. So kind of use that line of argumentation to demonstrate that the criminal law isn't doing what it's doing, and simply using it to express social disapproval of something, and as a result, all of these other human rights violations flow from it, is problematic from a human rights perspective. That's not to lessen, what a big task we have in front of us in terms of how do we deal with this, real belief in the expressive function of criminal law, and potentially thinking about alternative ways for communities to express their thoughts and disapproval about things. So I just wanted to add that. Thanks.
Yeah, Jaime, I wanted to engage with what you mentioned now about the expressive function of the law, and I think it's, yeah, what you're saying is making perfect sense. But at the same time, it's not only the social disapproval is the expressive function of the law, but also it's sometimes a way to obligate the state to acknowledge this violation. For example, if the state is completely denying a specific problem, sometimes pushing for a law is a way to actually make the state acknowledge the existence of this problem, and also hold the state accountable if the state is the perpetrator of that violation. For example, in Egypt, the state is a huge perpetrator of the sexual violence, specifically in prisons and in custody, as a way to intimidate people, as a way to extract confessions. If you don't have a way to hold the state accountable for these kind of violations by an existing law, how then can you how can you deal with this? So it's not only for the social front, but also for the state front.
Thanks, Dalia. I'll just follow up. I think that, when trying to figure out where it's legitimate to use criminal law, violence by non-state actors and by state actors is probably the area where we have the strongest argument for maintaining punitive approaches. And we do need a way to hold states and perpetrators of violence accountable. But I think all too often we focus on the punishment component of that. And when we think about states' due diligence obligations to prevent violence, to investigate violence, and to punish violence, we're usually that due diligence obligations is distilled down to criminalize and punish. And I think we would be better served to also focusing on the other obligations is to prevent the violence in the first place. And so if we have state actors committing violence, what steps need to be taken to root out those state officials that perpetrate violence, and to address the structural systems that enable that violence. So I think that we do need some amount of accountability, but it cannot just solely be focusing on the actual punishment of the action. It needs to go much deeper. So maybe broadening out, our analysis around this is helpful to that extent. But I do agree with you that I don't think we're at a place where we can completely abandon a criminalized approach to violence. I think it's a whole other realm of sexual and reproductive rights violations that are criminalized that we have a stronger argument to call for decriminalization and to seek alternative approaches. Thanks.
Thank you, Jaime. Just to move on to the next question from from Kat Watson, and she was saying that it's interesting, as I was just thinking the same thing when doing a legal research project in Nepal today, on Nepal, today. The criminal penalties for rape increase the younger the victim is. The question is whether these act as protective measures or not, given that increased punishment may actually deter reporting. Dalia, do you want to try to address this question?
Yeah, the increasing penalties is actually a huge problem. I think many of us facing. In Egypt, before 2011, the laws of sexual crimes, namely sexual assault, rape, and sexual harassment, these laws have been amended a couple of times before 2000, from 2008 to 2011, and also after this. And all the amendments actually increased the punishments to the extent that rape was actually punished by death sentence. The problem is, as I was talking before, is when you have a society that is not convinced that these kind of acts are actually crimes. So you face series of problems that actually lead to a miscarriage of justice. Like, you have the police not cooperating with the victims and do not actually train to listen to them. Then you have the persecution articulating the accusations in a very sympathetic way to the perpetrator. And then you have the judge himself not convinced that this is a crime, giving the perpetrator a very reduced punishment, sometime a punishment with a suspension, because they are not convinced. So keeping limited in just how to amend the law by just increasing the punishment is not at all innovative. It's just the state is resorting to the easiest way to say that they have done their duty. But I think when we propose actually alternative ways, for example, we proposed an alternative way for increasing the reporting of female circumcision. We thought that, criminalization of female circumcision in itself will not solve the problem, but now it's a crime anyway. So we have to work with that law. But the problem is that the law actually punishing the doctor himself or the midwife, at the same time also punishing the parents. So nobody is reporting. So we thought that we might try to encourage parents to report in cases that, where their daughters experiencing medical complications or sometimes death during female circumcision. So we proposed a legal amendment that would suspend the penalties on parents when they report or when they cooperate with the police and the persecution to reach actually the main perpetrator of female circumcision. And that actually proposal from EIPR was faced by a huge backlash from the pro-criminalization and pro-state intervention camp, that we don't want laws at all, that we are trying to give parents an alibi, and we are trying to decriminalize female circumcision. And it took us a very, very long time to reach a middle ground with those people. Of course, the state didn't pick up our proposal anyway, but I think it was a good mental exercise for us and for other human rights and feminist advocates to think about other ways other than direct criminalization to face a problem, or increase penalties as a way to punish the perpetrators of violence against women.
Thank you, Dalia. I just want to add that Diva also had a reaction to Kat's question, and I'll just read it out here in case any of the speakers also want to add to what Dalia was just saying. She was saying, I think the question is, do we want a regime of social disapproval enforced by the state, or do we want a system of accountability and healing? I'll move on to a comment, actually, that a question/comment that we got actually from Cynthia Rothschild. She was saying that I think I think we also have to climb out of the human right to privacy, not necessarily abandon it, but using that alongside other rights, some of which Jaime mentioned, but we also have to do some thinking. But we also have to do some thinking about that. Any one of the speakers wanna react to that? Okay. I'll move on to also another question that we got from Nelly Basili. She was saying, how can there be a move from criminalization to transformative justice within communities? It's really hard work, but it would be interesting to have case studies where that has been done successfully. Anyone has experience?
So I just wanted to react to that. I was thinking that, you know, if we had actually more case studies, you know, demonstrating transformative justice in a way that isn't solely focused on punitive approaches, and that if they were community-led approaches, that could be really moving, and that could provide some strong foundation for calling for alternatives. I think one groups of people around the world that we could look to, you know, in terms of inspiration for this type of work is indigenous communities, and thinking about how in more collective societies and communities they're handling dispute and disagreement within a community. I think that we don't do enough to engage with the indigenous communities and learn from, you know, millennia past of how we can address conflict in a way that doesn't lead to grave human rights violations. So that's just one idea I pose out to the group as well.
Thank you, Jaime. I just Cynthia just added that. I think, I'm sorry, Cynthia, it was cut out from my screen. I couldn't read the last part of the question. But she was saying that she was posing this question as a means to broaden our approaches beyond privacy and civil rights. And the issue was about connecting these issues to the right to development and economic and social rights and justice. Sinara, did you have any thoughts on this issue?
No, sorry, I was actually trying to address, I guess, the previous question. I guess it was Nelly's question on how do we work with communities and working with social disapproval, if I'm correct, social disapproval outside of criminalization. I don't have, or transformative justice within communities. I guess Jaime did point out something that's very interesting in with working with indigenous communities. I actually wanted to, it's not an answer to that, it's a comment related to it, is that we see sometimes communities' perceptions. For example, the idea that women who suffer domestic violence don't necessarily want the perpetrators to go to jail. We sometimes see that those expressions being used as a means to say that we shouldn't be doing much. So instead of using those perceptions, which are important to understanding how these conflicts are, how violence is very complex and how its results, and how just approaching it through criminalization is complicated, instead of using that as an entry point to a conversation of what alternative measures we should be using, it can sometimes be, it is sometimes used to say that we shouldn't be doing anything. So therefore, we shouldn't be addressing the issue at all. So I guess what I'm trying to say is that we often listen to communities only in a manner to find arguments or to find a way to say that to de-responsibilize ourselves or the state in doing stuff and doing anything else, and in sort of just saying, well, it's not even working for them, they don't even want this, so we shouldn't be doing much. And I guess we need to, because I don't have an answer to Anela's question, but I understand it is a very important one, we need to be able to listen to communities in a more effective way, and to understand, for example, when they say they don't want perpetrators to go to jail, they don't want them to be imprisoned, what do they mean? Why is that a question? What does it prevent them from presenting their claims to the criminal justice system, for example? So although I don't have an answer, I just wanted to point out that I guess this is also a starting point that we need to take more seriously when developing our arguments into regarding criminalization in general.
Thank you, Sinara. I asked you to comment a bit on Cynthia's comments and questions last comment as well, because of the piece about bringing in the discussion on equalities and economic justice as well into this work. And I know that you've done a lot of work around the Zika virus in Brazil and the interlinkages there between sexual and reproductive justice and economic justice. So I think this is also something we can touch upon, because this is something that research has done also and wants to engage in further.
Yeah. So I was thinking I could try and think of an example on the domestic violence legislation in Brazil. It was and it still is considered a very advanced piece of legislation, because it's not just conform to criminalizing, to saying that perpetrators should be punished, because it has a set of measures that have to do with prevention, and even go as far as to say that we should be discussing this issue in schools. It goes as far as to saying that communication outlets, news outlets, should be addressing this in a manner that does not enforce stereotypes. And it says that women that seek the criminal justice system or seek the system to get assistance should be assisted not just through the punishment to the perpetrator, but also through accessing social policies. So they have somewhere to go when they're not safe. So their kids have somewhere to go. So they have psychosocial support to dealing with the situation that they're in. And that's really important about I guess, the way that we wanted to address the issue in Brazil. But what has happened is that the criminal aspect of it has colonized everything else. So we have a hard time getting judges and people working in the criminal justice system and psychosocial professionals to engage in that area, because we keep saying, well, our focus is to just deal with the criminalization, the criminal aspect of it, so we can't really deal with the socio-economic aspect or the consequences. And I guess although it is not an easy issue to solve, we need to stress that they cannot go separate. They need to go together. And sometimes when we make our claims for change, including through criminalization, we forget to talk about those issues, and they're very intersected. They're very connected. What do we say to women who seek the criminal justice system to say that they've been suffering violence at home by their partners, and what they really want and really need is to have somewhere to go on the next hour, so they are no longer in danger? And we say, well, we can't really do much about that right now, but we can initiate a penal action, a criminal suit against him. So we need to see the connections. We still have a hard time. We see it in an abstract level, but we still have a hard time seeing the consequences of not addressing those in an intersectional manner, and seeing how even the fact that if women can't access reparation, if they can't access social policies, they might not even be able to come willing to come forth with the violence that they've been suffering. So so yeah, it's still not an answer, but it is. I want to insist that the domestic violence legislation in Brazil is a case in point of how the criminal approach can sometimes colonize everything else. And we come to this debate just saying, well, we tried it, but the most important thing was to have the criminal system in order to try and punish this perpetrator. So we may be able to take on the social aspects of it later on, down the in more years, in years to come, when we have more resources. So we keep postponing it, and that has not made much of an advance around here, at least. So yeah, I know it's not very optimistic, but I guess at least we need to be able to develop the argument and the language to say that they are very connected and they are very interlinked, and one affects the other constantly. And if we are going to address it in one way, we need to consider the other aspect, the social, economic, and psychosocial aspects of it as well.
Thank you, Sinara, very much. And then the last question we got on today was, is the expressive function of criminal law the only function it performs? What about its function to change the power balance between perpetrators and victims? Dalia, do you want to answer that question?
Yeah, I want to talk about the function of the anti-sexual harassment law in Egypt and its role actually to change the power dynamics between women and harassers and perpetrators of sexual violence. Because I think that we always use that example in Egypt as a success story of amending the law. But I wouldn't say that the law itself did this. It was a long process that started before changing the law, but the law really helped us in creating legal deterrence. When the first couple of harassers got imprisoned, the media started to address the problem more seriously. The problem that the media before this was actually talking about sexual harassment as a sensational issue, or as if they are covering kind of pornographic thing. But when the law changed, the kind of coverage changed, but not only the kind of coverage, but also the women's courage. The women felt that they have the right actually to confront the harasser, to resist what's happening. And the more interesting part in the anti-sexual harassment article is related actually to the discussions happening now about reducing the penalties, because many feminists, specifically young feminist activists, are now thinking that prison sentences are not just punishment for sexual harassment, and they are thinking of other ways like awareness raising or social service as punishments to the harassers. So it might be a cycle that sometimes you need a strong law, you need a strong grip for a specific period of time, and after you set the tone, after you create that kind of deterrence, maybe you should stop and think again of the process of decriminalization, because you would be by then actually succeeded in criminalizing the issue socially, which is more important than criminalizing it legally.
Thank you, Dalia, for that. I think that was the last question / comment that we've received from you all today. I'll just conclude today's discussion with just some final thoughts about what RESURJ wants to do with this work in the future. As based on this, on the outcomes of that meeting we had in April, and then a lot of the discussions that we've had since then, we would like to take this discussion forward and ultimately to design a more comprehensive advocacy strategy that seeks to establish restorative rather than punitive justice. Restorative, yes. In other words, justice for survivors. We not just revenge of the perpetrators. And we want to make sure that the survivors' rights are respected and protected, and and that these violations will not keep reoccurring. and we'll not be working on silos on this issue. We'd like to advance and establish the interlinkages between sexual, economic, and environmental justice, and promote an approach that seeks to uphold all these areas. We the outcome statement from the meeting we had on in April is available in English, Spanish, French, and Portuguese, and very soon it will be available in Arabic as well on our website. I'll post the link right now to our in the chat box, and we invite everyone, all allies, and all of our allies and or all other interested actors, take a look and to continue to engage with us further on this issue. And we look forward to hearing back from you, and we look forward to other opportunities like this one where we can discuss this further. Thank you, everyone.